Okay, well, welcome everyone to LAW2023 Online. It's the spring civil litigation shaping the debate. First of all, let me introduce myself. My name's Andrew McLaughlin, and I've got with me an esteemed colleague in Helen Swaffield. Today, we've got a question and answer session. It's due to last 1 hour and covers some pre-submitted questions on the topics that both Helen and I have delivered by way of webinar and detailed notes in support. By way of introduction, I'm a consultant solicitor. My name's Andrew McLaughlin. I've got higher rights in both civil and crime. I sit as a recorder in the Crown Court, but perhaps more significantly for the purposes of today, a recorder in the County Court and also a court examiner appointed by the Lord Chancellor to take witness evidence in various ways, and I've got a significant experience in civil litigation, commercial litigation, and I get quite a lot of training from the Judicial College on how to really put the rules into practice, so to speak, from the judicial perspective. My two areas that I covered were firstly Part 36, the last 12 months, and also dealing with the introduction of fixed recoverable costs, or rather the extension of the fixed recoverable cost regime, which is due later on this year. Helen Swaffield, in fact, is a barrister. She's head of contract law chambers. She's been a barrister for over 20 years, has worked in London and internationally before starting contract law chambers at Chancery Lane in London. Currently, she's involved in large multi-party cases involving hundreds of claimants in the High Court, and she's given seminars on contract and commercial subjects as well as litigation. For the Spring 2023 Online, Helen covered sessions where applications against litigants in person, and secondly, keeping up with witness statements. So really, we're now going to, as it were, have a conversation and a dialogue about a number of questions that have been raised in relation to the sessions that we've been undertaken. So we'll start addressing those now, if I may. And it's really a question to me, first of all, a question raised, which is this. How much interest can you claim when you're making the Part 36 offer from the end of the relevant period? And so dealing with that question, if I may, it's as follows. Remember that the rules changed, but Part 36 does allow you now to claim interest from the end of the relevant period contained within the written offer that you make to your opponent. So the first point to make, of course, interest can only run from the end of the relevant period in the offer. It's probably not going to be an effective Part 36 offer if you start claiming interest within the relevant period, and indeed, under the rules, interest is deemed to be included in the offer that you make. So after the end of the relevant period, we turn to the case of Calon Constriction, which you'll recall was in the notes, and Calon Constriction, in fact, the Court of Appeal case, got, in fact, the rule makers to change Part 36 to incorporate it. And basically, the Court of Appeal in Calon said you can actually make interest, as it were, in the terms of your offer at literally whatever percentage rate you felt appropriate. So, for instance, if you wanted to make it 15% per annum or 20% per annum from the end of the relevant period, that was a matter entirely for the offeror. And what the Court of Appeal said in terms of an approach by the offeree, so the recipient of that offer, the best approach the Court of Appeal suggested was that, in fact, if that was considered to be punitive interest in in inverted commas, or interest that really the offeree couldn't stomach, then their approach would be to go back to the offeror and suggest an alternative rate of interest, or indeed, which obviously going to be lower, or make a Part 36 offer themselves to deal with actually resolving the matter. So that was, as I said, the answer to that question. I don't know if Helen wanted to say anything more on that particular question or not. So over to you, Helen.
Yeah, I think it's a great idea to put some contractual interest, because that's what you're doing in your offer, so that that you've got, if you're the claimant, not if you're the defendant, obviously, making an offer, but if you're the claimant, it's a good idea to think about putting some contractual, effectively it's contractual interest in there, that the court can use when at the end, when they're discerning the cost consequences.
Yeah, and I think the other advantage to the offeror is if a defendant does wish to accept the offer, they know what we've got to pay. So they may be accepting, sort of maybe 6-8 months after the offer's made. They know what they have to pay.
Yeah.
So thank you for that, Helen. And over to you now. A question that's been raised. It's in relation to witnesses. Vulnerability of witnesses, I suppose. Can you give examples of special measures that can be used for vulnerable witnesses?
Yes, thank you indeed. So this was our witness statement PowerPoint. Towards at the beginning, we discussed the practice direction and the new measures in which we must identify vulnerable witnesses. I've had an incident where certainly cross-examination was halted for that witness to take a break, and unfortunately that hadn't been picked up in any of the pre-trial documentation, so the witness hadn't been identified as vulnerable. So we were very long and very much in excess of our time estimate, which of course threw everything out. So that was a pointer to identifying how their vulnerability will impact, and it's always cross-examination where they're going to feel most under pressure. So there was a couple of cases to think about. One was the Gunning case, which is a recent case, where things went a bit too far because the questions were provided to the other side, the cross-examination questions in advance. I mean, that's a big concession, really, if you're running a trial. But they had then discussed those questions with the vulnerable witness. So, and the court said, well, actually, that's too far. Having them in advance is one thing, but sharing them with the witness is another. But Freeman and Pennine Acute Hospitals NHS Trust, also another 2023 case, was about one side complaining about the use of Teams and leaving the witness in their own home to withstand cross-examination remotely. We're very used to this after the pandemic, and the judge said, well, look, Teams was fully remote, it worked well, and I decided, he said, that we would use that for Mr. Orton, as my 3 reasons for remote evidence remained, and those were partly that the technology was okay, and secondly, that although Mr. Orton started a little quietly, his evidence proceeded smoothly, and thirdly, that the cross-examination was undiminished, and in fact, the judge said it was very effective despite being remote. And I think actually it's good to think these, a couple of things really. One, if you have got a vulnerable witness, you need to get that out there in the questionnaire as soon as it comes in, so that you can identify them, because accommodation must be made. It will have an impact on the timetable, and not just the length of the trial, but also what we do with which witness on what day. And if you go over then and you've got lots of witnesses, then everybody has to be rewarned, and travel arrangements, and people who've got childcare. Oh, it's a nightmare, as Prince Harry probably understands. So getting your witness there on time is a major issue. And so, identifying this up front and thinking through the impact. So there are possible breaks on cross-examination, be doing it remotely, maybe getting the questions in advance. So that does seem to me to be quite a big concession. Whether you'd get that from the other side after the case we've just discussed, I don't know. But really trying to facilitate it and think in advance. And of course, the definition of vulnerable is very wide indeed. So you don't want to get to trial and then find out that they just can't cope, or they can't understand, or there's some other issue that means that they start. In my case, the witness began to just have repeated asthma attacks because they were under pressure. And I very much wish that the other side had thought about that in advance, so that we could have handled. I could have done the cross-examination remotely. That would have been no problem at all. Nobody wants somebody to have an asthma attack every 10 minutes. And so it was really difficult to, and I found it difficult as well. I couldn't get any evidence that I wanted to get from that witness in cross-examination. So it sort of failed on every count. So there were things, I think there are things that you think you need to think about in advance and perhaps discuss with that witness, so that the aim is that, as the judge was saying in the Freeman case, to get them through their evidence as effectively as possible, which means really as expeditiously as possible, so that we can hear what they say, they have a chance to answer the question, and those questions can then be recorded either by note form or something remotely for the future. I was going to just reflect that back to our recorder here to say, what have you seen, Andrew, for vulnerable witnesses in court?
Well, certainly a lot more emphasis being placed by judges in relation to case management. I think, as you've said quite properly, Helen, this really needs flagging up as soon as possible in the process, because what you don't want is surprise, where someone, for instance, has an asthma attack, and then, of course, it completely dislocates derails the trial process in a number of ways. One, because of the length of time it's going to take, and obviously it's not been factored in at any stage. I think what's happening actually is that civil cases are slightly adopting what happens in crime. Whereas, because I'm sort of here with interest, your sharing of the questions. In certain criminal cases where there is a vulnerable witness, often because of age, and the like, they may be the alleged victim of sexual abuse, by way of example, with learning difficulties, by way of example, it's often de rigueur to prepare a series of written questions for a witness who's got, a series of vulnerabilities, but the questions aren't shared with the witness before the questions are approved by the judge, and the parties are aware of what questions are coming, and it may be a linguistic structure to simplify questions so that the witness themselves are capable of understanding the question. I mean, an example for me was, in fact, ticks two boxes really. Your litigant in person with depressive disorder and anxiety as well. And during the trial, because they were in person, I actually specifically said, well, no, I'm having a break now because you need a break. They were saying, oh, no, we'll carry on. And they clearly were losing composure. And they, as I say, they weren't a witness. They weren't at that stage. They were cross-examining, because the anxiety builds up. The anger was also building up, and you could see it, becoming quite a little less than courteous or well-mannered. But yeah, I mean, for sure, I think courts are really, what I'd say, Helen, to sort of finish, it's really the burdens on the parties to bring these matters to the court in terms of case management issues, because the courts will accommodate them, absolutely. There's a lot of judicial training going into accommodating, making reasonable adjustments. Equal treatment bench book, by way of example, is a massive reference book for everyone to look at. So there's a definite sensitivity to sort of input and vote. So thank you for that. So I think a question to me, another question that's been raised, which I think we can do relatively straightforwardly, hopefully. What is the best way to make a Part 36 offer? And again, I covered this in the Part 36 delivery, which is use form N242A. That is the practice form that has been crafted by the Civil Procedure Rules Committee since the changes a few years ago. It's all embracing. Why do you want to use it? Because the wording complies with Part 36. And there are any number of cases, I'm sure Helen's aware of them, where actually quite, reputable magic circle type city firms can't get a Part 36 offer right. And you're thinking, wow, and how does it happen? Because they incorporate the Part 36 offer in a letter. And because the wording of the letter is in itself isn't necessarily wrong, but it's sent on a different day. And the wording in the letter says you've 21 days from today's date, i.e. the date on which the document's prepared, the email, and they send it the next day. So you've actually, the recipient's only got 20 days to think about it, and that's a recent case involving Essex County Council and a waste management company. No, actually, in that case, the High Court judge, and frankly, I think because he'd taken a pretty deep dislike of the evidence of the waste management company, allowed that to be an effective Part 36 offer, even though it wasn't actually quite compliant with the rule. Now, as I say, as practitioners, we don't want to be in a position where this is a sort of multi-million-pound claim where you're sweating on whether in fact you've made an effective Part 36 offer. So my suggestion to that is N242A. Whatever wording you want to put in that offer that meets the requirements of the specifics of the facts of the case, yes. Any persuasion you put in a letter. So the letter is an adjunct to the actual form itself, and therefore all your sort of page after page of sort of persuasion as to why it's a great offer is actually separate to the actual terms of the offer itself. So I think that's the best practice, so that you seek to insulate yourself from the risk of making an ineffective Part 36 offer, or being at the risk of making one and relying on some sort of judicial discretion to allow it to be effective. And in the Essex case, it was an effective Part 36 offer. So all the benefits flowing to Essex County Council came from that Part 36 offer, indemnity costs, interest on indemnity costs, etc., etc. So there was a lot of additional benefit to the claimant in ensuring that it was effective. So that, as I said, I don't know if you have any other comments you wish to make about that.
Well, I'm not going to even start because things do go wrong, don't they? And yeah, it is tricky, isn't it? Sometimes less is definitely more. I agree with you on this one.
Okay, well, moving on if I can, because it is I think an interesting question actually. To be interesting to hear your take on it. Is how are adverse inferences used to best effect?
Yes, well, this was from our witnesses PowerPoint on our session, and we have had some very good cases setting out the basis upon which you can use an adverse inference. And of course, I've worked with some fantastic practitioners over the years, and I remember one in particular who said that the more you ask them about their case, the better they get at it. And there is that that point, isn't there, where you think, right, okay, they're not putting somebody up to give evidence, or they haven't disclosed a document, and there comes a point where you think maybe the better thing to do is to make more out of the absence of the witness, or the absence of the document. I think the thing that you've got to do is make, decide upon your strategy, really. Either you push it or you exploit it. And if you want to exploit it, then you have to be able to set up that exploitation to draw the inference. So an adverse inference is drawn by the court, which is a sort of a diminution of the evidence. In other words, something is wrong about the fact of their absence. So there's a question mark raised, and that question mark undermines the credibility of the whole case because of the absence of that witness, but only if there isn't an appropriate explanation. And people are very good at coming up with them. So, you've got to think, gosh, am I going to just back myself into a cul-de-sac where I'm neither making enough about their absence, nor am I able to draw the adverse inference? So in the recent case of Thomas Barnes and Blackburn and Darwin Borough Council, the court said, look, we are keen to draw these inferences if people don't turn up who we would have expected to be there. But at the one end of the spectrum is a party who's been unable to call a witness, who would have given an open and honest account for reasons outside their control, typically illness and, a supporting medical note. The intermediate position, for reasons which have not been sufficiently explained or justified, the party's not called a witness who was involved in the events in question on that party's side. So in other words, we would have expected them to give evidence, and you haven't really explained why they're not here. And at that stage, the court is beginning to raise doubts. Let's put it that far. Now, at the other end of the spectrum is where the court is being invited to draw a positive adverse inference, which sounds like a tautology. In other words, undermine, diminish the credibility and the evidence that's been given on the part of the other side in relation to a specific issue that could have been dealt with by somebody, but for their absence. And that's where it has been insufficiently explained, unjustified, and they are, as the case puts it, a crucial witness. And I think it's really interesting because when you're thinking about which witnesses you need, then it's important to contact them in plenty of time. If you need the summons, get the summons, or replace their evidence from another source. And that may not be possible because they're the only people who can give direct evidence or corroborative evidence. And if that's not possible, you have to be able to account for their absence. So it's really making the most of the absence of a witness.
Thank you very much indeed. Okay, I'm just going into again dealing with a couple of points really that have been raised because I'm always conscious of time. And this is a topic that was covered, which is to do with fixed recoverable costs, which is a massive change. And a couple of questions are: is it going to be delayed? And how will practice change as a result of the changes? And again, this was covered in the notes. It's the 1st of October 2023 when fixed recoverable costs come into play. Spoken to a number of people, no one thinks that this will be delayed any further. That there's been significant work done by the Civil Procedure Rules Committee over a year, in fact, of getting rules in play to be effective from the 1st of October 2023. And in fact, so much so that there are now draft rules out there for practitioners to look at. They've not been, as it were, signed off as such, but they're out there in detail, changing pre-action protocols, setting out tables for the amounts of costs that can be recovered between the parties, with as it were, detailed practice directions as well, and with the appropriate changes. So it would, I think, be very, very surprising if this date were put back once more. That huge groundwork done, completed, rules out there for digestion, as it were, so that there's no, as it were, big bang surprise in the 1st of October when these come into play. The major change, I think, frankly, is twofold. One, expanding the range of fixed recoverable costs in the fast track for different types of work, but perhaps in terms of fee, return and revenue, a similarly significant change is, as it were, taking fixed recoverable costs to £100,000 claim value in the newly entitled intermediate track. That will have a significant impact, which deals with the second part of the question. How will practice change? Frankly, it will change because your client, either way, is either paying less or receiving less in this fixed recoverable cost regime compared with what they otherwise may well have recovered under a summary assessment of costs in the fast track or a detailed assessment of costs in the multi-track. And I think that the rule changes, so to speak, I think have done what they would consider their level best to reflect upon inflation, lots of consultation about the figures and the like, but I would venture to suggest that the figures in the tables, both in the fast track and the intermediate track, are not generous. They're likely to be lower than you otherwise would recover for your client had these changes not been in play. What impact does that have? Well, it means, of course, unless you reduce your rates, either by, fixed fees or by reducing hourly rates below, guideline hourly rates, it means the client pays more at the end of the day. If, for instance, you're a successful claimant, I'm venturing to suggest it's always swings and roundabouts, I appreciate that. But generally speaking, you will be recovering less from the paying party than you otherwise would do had this new regime not brought into play. And therefore, I suppose what follows on from that is making the client aware right at the beginning of the process that there is likely to be these differences. Because what fixed recoverable cost brings to the table is information for the client. That yes, you may be able to exempt yourself from an intermediate track case, but the guidance seems to be these are going to be exceptional cases that get outside the fixed recoverable cost regime. And all right, we might pontificate as to how and when. The answer is it's going to be very, very infrequent that will happen, and therefore the client needs to be appraised as soon as they're signing the client care letter, that they're aware that they may well be likely having to pay more, unless, of course, your policy changes. And in fact, this will also have an impact on the bar as well, because the fixed recoverable cost regime, specifically in the intermediate track, cover fixed recoverable costs for advocates at trial, in pre-settlement hearings, in also advising in conference and the like. All those are now fixed recoverable costs. And the rule makers have been quite cute, I suppose, in calling them advocates. So it can be a solicitor or a barrister, but it clearly will have an impact. For instance, let's say a multi-track as of old, which was, let's say, worth 70k, that will go into the intermediate track, assuming it's 3 days or less. the fee for counsel, in my experience, on the table that they've produced is significantly less than what counsel would otherwise be charging had these fixed recoverable costs. Now, maybe there's a debate to have with counsel's clerk, no disrespect, Helen, when talking about that, but maybe solicitors may want to have a chat to counsel's clerk about, well, what are we going to do about this new landscape? Fixed recoverable costs. Of course, the answer may be, well, if you don't want to instruct Mr. or Ms. X, then there may be someone who can do it for less, who's less experienced and less talented. But as I say, those are the changes. I think fundamentally getting your client on board with knowledge. I mean, my experiences of being a complaints partner from a solicitors in a litigation department was the surprise about a bill, not necessarily the outcome of a case, but actually, why won't we tell them about this sooner? That we'd have this large demark between what we were getting and what we were actually having to pay. So I think that sort of covers those 2 points. I don't know if you wanted to chip in at all, Helen, with
no, it's the 2019 report, isn't it, from Jackson? It's been there, or it's been a slow trainer coming.
It has, yeah. Well, yeah. In fact, Jackson wanted to introduce fixed recoverable costs in the fast track in 2013.
Gosh.
He wanted that to occur, but I think from what I gather, the Civil Procedure Rules Committee said, well, actually, thanks, but no thanks. We're just too much on with all these changes you've already introduced, because we're introducing, because there's actually, if you think about it, there was always been a bit of an inconsistency in that you can run a fast track trial, have a summary assessment, and there'd be no cost management at all. Whereas if you went in the multi-track, under CPO3, you'd be subject to cost management. Where, of course, in the fast track, there were smaller value claims, probably less complexity, where the risk of disproportionality was all the much greater. So that lacuna, so to speak, as to a large extent now being filled. So moving over to you, if I can, Helen, to. Is it okay to deal with a litigant in person question?
Do.
Absolutely, thank you. Okay, should the court apply different principles to litigants in person?
They should not, no. And my favourite case, because we've all had to deal with them in unexpected places. They get into the High Court all over the place. And I've had some experience of having to deal with them on the other side. And I think that my favourite case, the one that I put in every skeleton argument when there's any hint of a litigant in person, is Morris Kay's case of Tinkler and Elliott, which is 2012 from the Court of Appeal. And it's just brilliant because it says, and it was at slide 11, an opponent of a litigant in person is entitled to assume finality without expecting excessive indulgence to be extended to the litigant in person. And really what we're having to do is extend indulgence. That's what we have to do. There is indulgence in the sense of enabling them to get through the process, but not excessive indulgence, which then takes them into a different place as far as the application of the rules and indeed legal principles are concerned. And there was quite a good illustration of that really with Barton and Wright Hassel, which was a hard case, I felt, in 2018, where Wright Hassel didn't point out the difficulty or the error in service of the claim form until it was too late. And Mr. Barton took them on and went quite far with it. But the court held the line and said there cannot fairly be one attitude to compliance with rules for represented parties and another for litigants in person. And that is right, really. However, having said that, I do think that you are more likely to enforce that if you have some evidence that you've extended indulgence to them. And a good example of that would be giving them for example, the skeleton argument in advance, giving them some of the case. You can get them on Bailey, so you can put them in your footnote as a hyperlink. And if you've set it up, and I tend to just be very, very quiet and not say any more than I absolutely need to with litigant in person on the other side, and just ask the court to help so that they can show the litigant in person what to do and so on. Could your lordship, could your honour explain to my opponent, so that that is gently dealt with. And if you approach it without all guns blazing, I have found that you tend to do better, because we're all working towards getting them through the system. And so there's a little bit of indulgence, but not excessive indulgence, tipping over a sort of a different approach to the rules. That's my top tip anyway, but I know it can be very vexing, really.
Yeah, I think the litigants in person are often at trial an issue for the judge. Well, frankly, you cannot tip over into giving advice, and that's quite clear, because it's an adversarial process, and it's got to be fair also to both parties. But I agree with you, Helen. Explaining the process often can take quite a fair bit of the anxiety and concern that a litigant in person has. And I think the other thing, just chipping in on this one, is not all litigants in person, they're not all the same. They're not, some can, in my experience, have been extremely courteous, deferential, respectful of their opponent. On the other hand, 2 days later, a completely different approach of aggression, ill-mannered, discourteous to both opponents and the court. I mean, that then needs reining in, and that's aside from maybe ignorance of the law and just running the case in a chaotic fashion, which sometimes can happen with LIPs. And so, yeah, thank you for that. I'm going to move back to a question for me, if I may. Again, going back to part 36, how does a court view competing offers, both of which have cost consequences for the offerees? And the reason I'm dealing with this is because it was quite an interesting case, and I think it was Mrs. Justice Collins who opined on this on an appeal. But it's interesting in the sense that, one, it was a personal injury matter which we're not dealing with, but it was competing offers. The claimant said to the defendant, we want 90-10. Our offer on liability is 90-10. And it was a 100% claim. The defendants, quite cannily, made a financial offer to the claimant. So the defendant's offer was, well, we offer you £5,000. Off we go to a hearing. What happens? Well, the claimant wins 100% on liability, but only recovers less than £5,000 in damages. So both Part 36 offers bit. The claimant said, well, I've won, look, I made a Part 36 offer 90-10 in my favour. I've got 100. I'm entitled to all the benefits that flow from my award of damages. The defendant said, well, no, you didn't win, because we made you a financial offer and you've actually failed to get a judgment that's at least as advantageous as that offer. Anyway, off we go to Rowena Collins in the High Court, and she says, well, let's look at this. Her answer was the defendant. The defendant's offer is the offer that I'm going to say is relevant to the outcome of the case. Because what she did is she sort of, in a rather practical way, said, well, look, these offers of 90-10, it was a road accident, and it was never going to happen 90-10. There was never going to be an actual outcome of 90-10. It was either going to be nothing or 100%. So she considered that to be a rather artificial type offer. But on the other hand, she then said the defendant's offer was actually a financial offer, and the financial outcome has been, in fact, they've done better than their own offer in these circumstances. So she allowed the defendant to have their costs and interest on those costs from the end of the relevant period. So it's a bit of an unusual case in that sense. But what I was going to say is that case is probably quite fact sensitive, because it was the High Court judge actually paying proper deference to the fact that these sorts of offers are out there, albeit in the personal injury world. So moving on, if I can, to yourself, Helen, with another question. If we deal with litigants in person, if that's okay, what are the different bases for an abuse of process argument?
Yes, well, I mean, if we're not dealing with the abuse of process for subsection C, which is if we're not dealing with, sorry, a strikeout for subsection C, which is where you've got a Denton situation when you've broken the rule. You concentrate on abuse of process proper, as it were, then it divides into three subsections, really. One of those subsections is that there's no reasonable cause of action. And I think I put in, you probably remember the PowerPoint of the very attractive looking chocolate coloured Labrador, because of course they are very important to us, but they don't have capacity in which to bring a claim. So it's just proper nonsense. So that's 3.42a. It's incoherent. It's just doesn't make sense. It's not a legally recognisable claim. I remember talking to a practitioner who used to have, do you remember the green form legal aid? And you used to get sort of some money for 30 minutes of, hello, I want to sue what was then the Queen, okay, fine, tell me about it. And, you'd send off your green form. And that's the sort of situation we've got there, really, no reasonable cause of action. There is also another subsection, which is the inherent jurisdiction of the court, which is really wide, and that's subsection 345. And that could be anything, where the court feels as though they need to protect the person often from going any further for a sort of costs situation. But typically we can sort of, it's like one of those elephant questions, isn't it? We can kind of spot abuse of process, and there are very lengthy and well-written notes to this in the White Book. But it would be things like litigating again, relitigating, and you have things like the rule in Henderson, which is tricky because it can be applied to things like an issue estoppel, where you've already got one at the moment, where they're reopening a Tomlin order, and you think, hang on a minute, it's a bit like zombie litigation, isn't it? And they keep coming back, or you've got other strains of abusive process, which include oppression, where it's almost harassment or a collateral attack on something that's happened earlier, or you're duplicating subject matter. And there's quite a nasty one where it's not what you have pleaded that creates that estoppel, that barrier to coming back again. It's what you should have pleaded, you missed that point. So yeah, there's quite a few, and it's not just the claim, it can also be the applications as well. So haven't we done this security costs before? Because you can make repeated applications, but something has to have changed in the meantime to enable you to have another go at security for costs, for example. So yeah, it's like one of those really sort of elephant questions. I know it when I see it, but you want me to describe it. Definitely different threads to abuse of process.
Well, thank you for that. I think I agree with you. It tends to be quite sensitive, but when it, as I said, your chocolate Labrador point, I think also, I'll just briefly say that it looks as if it's an area that tends to be slightly expanding in terms of courts being more open to allowing abuse of process, to actually, that's sort of certainly my take on
Or
it.
making a decision that the action or the
Yeah,
application isn't
yes,
process.
yeah, not having to cull evidence in if you like to, your non-chocolate Labrador type matters. It's a bit easier often, often for defendants to strike out claims where actually, because I think we've got another question on this, so I'll leave it at that, and come back to that to that, mindful of our time. So, I mean, a question that I'd got in relation to fixed recoverable costs is about will solicitors need to change retainer letters as a result of the changes that are coming in play in the 1st of October 2023? And I think my answer to that is yes, you're going to have to. I think because I've already discussed this to some degree, it is now a known in the words of Donald Rumsfeld. You know what the fixed recoverable costs are going to be if you are in the intermediate track to some degree, because all right, there may be arguments about the value of it, but you'll have an idea right at the outset, particularly if you're a claimant, what you're going to be able to recover from the other side out with indemnity costs arguments and arguments of conduct and the like. So how will that change your retainer letter? Because what I'm going to suggest is maybe give an example in your retainer letter. If the best example that you can give of what you think the case is worth. So if it's a £60,000 case with not much complexity attached to it, it may go into a band 3 of complexity. You've got the numbers on the table, and you can protect yourself and insulate yourself by saying, well, at best, we consider now at this juncture, subject to review, the following, and then you tell the client what they're likely to recover. And then you will be able to say, well, and here's our charge out rate, etc., etc. The various charge out rates depending on who will be dealing with the matter. And I think because it's consumer driven, the client care, the retainer letter needs to be in as simple as English as possible, and be demonstrably capable if it does go to a court, for a court to look at these, for a court to say, well, yeah, it's quite obvious what this letter was saying, and giving examples of, so you can, insulate yourselves from the risk of being, a client being surprised in inverted commas, i.e. not really surprised, but just wanting to reduce the bill. Pardon me for being cynical about that. Or actually someone who is genuinely taken aback when there's a large bill also due, having won their case. So give an example of it. And obviously when you're reviewing costs in a case, you may want to revisit that by saying, well, actually, we've now considered that this is a more complex case. It's worth £70,000. Therefore, the recovery from the other side is that much greater if we're totally successful. And so you've got that dynamic approach to keeping the client in the loop with regard to costs, rather than it being some sort of amorphous, well, how long's a piece of string? How long will we take to get this case to trial? And that will determine also the amount of costs that we will incur and the amount of costs that are recoverable. It's less, as I say, amorphous than it once was. And I think it does put greater obligations on solicitors, to get this right. There's been a number of appeals where on costs where the solicitor assessments being carried out, and the courts, I think, ultimately saying, well, providing you've explained it to the client, and there are no surprises arising, will uphold what's appropriate. Where solicitors often fall foul of it is where there are areas of simply areas that they haven't covered ever. in the piece of litigation that they're dealing with. And therefore, the genuine surprise from the client is therefore resonates that much more. I think, as I said, a final point is it's very much consumer driven. We live in a consumer driven age, and that, I was going to say, and I will say, I just wonder how many of our clients really read every page of a client care letter that they receive. They trust you to get it right. They trust you not to exploit a position, and they simply, that's from Mr. Smith, Ms. Jones. I'll sign it at the end, because I've got a relationship with them and I know they're going to do well. So I'll finish with a final question, which links into what Helen's just been talking about, with the difference between summary judgment and abuse of process. If you could just tell us a little bit about that, Helen, and give some practitioners some steer on that, please.
Yeah, I mean, this is, and normally you often find that an application to strike made at an early stage would be both. But there is a difference. I think I put it in a little table actually in the PowerPoint presentation. And summary judgment can be done on just sort of legal principle alone. It doesn't necessarily have to have evidence. So if somebody's pleaded something that's completely wrong, doesn't exist in law, then you could use summary judgment just without any supporting evidence at all, because there's no real prospect of success under CPR 24, or there's no reasonable cause of action under CPR 3.4 either. Usually with summary judgment, the difficulty is, and that's why you see the applicant witness statement often made by the solicitor, is that the more you sort of go into the evidence on why I should get summary judgment, the more you kind of sew yourself into a trial. So it is quite a sort of strategic and difficult supporting witness statement, I think, to make for an applicant for summary judgment, because you don't want to be too tendacious and introduce things that necessarily then the respondent to the application comes back and says, no, it's this way, not that way. And of course, then the judge will say, well, actually, there does seem to be a difference in the evidence. You really do need some slam dunk points, and you can run those slam dunk points if they exist, both under CPR 24 or under CPR 3.4, where the cause of action is not a successful one. Generally, though, summary judgment is limited to evidential points where they just don't have the evidence to bring up their statement of case. And of course, you don't have to do it for the whole statement of case. You can just cherry pick the issues that you just feel they can't get home on, or better still, you've got evidence which just blows it out of the water. So you can do that provided you have got the evidence to support that, or you can use it for legal principles or legal causes of action which just are doomed to failure. Abuse of process is limited to the statement of case. You shouldn't have any evidence with abuse of process. It really is, there's a problem with the pleading, there's a problem here because it doesn't work, it can't work, and this just does not exist. So it's a pretty bad sign, really, having an abuse of process claim against a statement of case. It means that it's fairly weak. Whereas with summary judgment, I've certainly been an applicant and a respondent, and I think it is the court just saying, well, there's the EasyJet principles are quite well known on this. There isn't any reason to go on. I've got everything I need to hear it. There's no reason to postpone this issue at all.
Right, well, thank you very much indeed for that, Helen. We've actually, unfortunately, run out of time for the day. And I think, just in conclusion, I think the topics that have been covered are quite detailed, interesting, and also very practical for practitioners, particularly in 2023. So thank you for watching today, and also thank you for Helen again for her interesting practical insights into the topics that she's been dealing with, and as ever comes with trial experience to share with us. Don't forget to join the solicitors group LAW2023 Online community. That's on LinkedIn. That continues this debate, and also includes exclusive offers for future events. If you purchased an online course, there's still time to watch the pre-recorded content, and your expiry date will be displayed next to the webinar. For those of you who haven't, there's still time to buy the complete event, including a recording of this session. Just go to www.thesolicitorgroup, all one word, .co.uk, and you'll find the online exhibition. The exhibition's open for anyone to visit, and if you've bought the entire package, you can claim your free 1 hour CPD webinar from the webinar learning catalogue, and that's worth £35 plus VAT. Finally, after viewing the online course, please complete a feedback form that's available in the related links section, and you'll receive your CPD certificate via email. So without further ado, can I thank you all again, and in particular Helen, for contributions this afternoon. I think I'm speaking both of us. Have a great day. Thank you very much indeed.